The Supreme Court has just agreed to hear a massive Second Amendment case, one that could reshape how gun rights are treated across the United States. Right now, in about 5 states covering over 20% of the U.S. population, the government has flipped the Constitution upside down. You now have to opt into your Second Amendment rights on private property. That means in states like Hawaii, California, Maryland, New Jersey, and New York, the default rule is no guns allowed, unless the property owner gives special permission. And today, that very rule is being put to the ultimate test in front of the Supreme Court. So let's break down what this case is about, why it matters, and what could happen next. If the Supreme Court upholds these laws, the Second Amendment could become a hollow promise for tens of millions of Americans. We're talking about 1 in 5 citizens living under a legal framework where they have to opt in to exercise a constitutional right. But this isn't just about 5 states. It's about the direction the entire country could take next. Because if these laws survive, you can expect more states to follow fast. This is why the case the court just accepted is such a big deal. It's not about fringe issues or technical details. It's about the core question. Can the government decide for private property owners that guns are banned everywhere by default? Here's how it works in those 5 states. If you own a business, an office, or even a private property that's open to the public, your property is automatically considered a gun-free zone, unless you post explicit signs or give express consent allowing firearms. In other words, the default position is no guns. If you want to change that, you have to take action to opt into the Second Amendment. And if you're a lawful concealed carrier walking into a shop or restaurant that hasn't posted permission, you're breaking the law, even if the owner wouldn't have cared. Now, think about this for a second. No other constitutional right works this way. You don't have to ask permission to wear a political shirt, carry a Bible, or display a religious symbol before entering a business. But in these states, when it comes to the Second Amendment, you suddenly do. Supporters of these laws claim they're protecting private property rights, saying owners should decide whether guns are allowed. That argument sounds good on the surface, but it's misleading. No one is arguing that property owners shouldn't have control over their property. Of course, they can say no guns if they want. The real question is, should the government be the one making that decision for them before they even get to choose? That's what these laws do. They strip property owners of that choice and replace it with a state-imposed ban. It's not protecting private rights. It's the government deciding what your property policy should be unless you publicly declare otherwise. That's the issue now before the Supreme Court. The case that brought this to the court is Wolford versus Lopez, coming out of Hawaii. On one side, you have Wolford and other lawful gun owners who argue that Hawaii's law violates the Second Amendment by setting an unconstitutional default ban. On the other side, you have Attorney General Lopez defending the state's position that it can regulate guns this way in the name of safety and property rights. Here's what happened so far. A federal district court in Hawaii agreed with the gun owners and blocked the law. But then, the Ninth Circuit Court of Appeals reversed that decision and sided with the state. The appeals court claimed that nothing in the Second Amendment requires private property owners to allow armed individuals to enter. Critics say that argument completely misses the point. No one is saying owners must allow guns. The issue is that the state has taken that choice away and decided on behalf of everyone. That's the heart of Wolford versus Lopez, and that's why the Supreme Court's decision to hear this case matters so much. This case doesn't just affect Hawaii. The same type of law exists in California, Maryland, New Jersey, and New York, and more states are considering similar default no-gun policies. Together, these 5 states represent over a fifth of the entire U.S. population. If the Supreme Court rules against these laws, it could immediately strike down similar measures elsewhere. But if the court sides with them, it could open the door for half the country to do the same. That's why this isn't just a local fight. It's a national one. In an unusual move, the federal government stepped in even before the court officially took the case. They filed what's called a friend of the court brief, urging the justices to hear it and to take a closer look at what's happening in these states. Their point was simple. If this pattern continues, it effectively nullifies the Supreme Court's earlier ruling in New York State Rifle and Pistol Association versus Bruin, which reaffirmed that Americans have a right to carry firearms in public for self-defense. Because if the government can just redefine public as almost nowhere, that right becomes meaningless. Now, when the Supreme Court accepts a case, it doesn't always take on every issue inside it. In Wolford versus Lopez, the justices are focusing on one key question. Can the government make the no guns default rule for private property, forcing owners to opt in to the Second Amendment? They're not looking, at least not yet, at related issues like which places can be labeled sensitive locations, how far back in history courts should look when evaluating gun laws under the history and tradition test established by Bruin. Those are big debates for another day. Right now, the spotlight is entirely on this default rule, and whether the Constitution allows the government to make citizens opt into their rights. The court will hear oral arguments this winter, with a decision expected next spring or early summer. If the court rules against Hawaii, it will likely invalidate similar laws across all 5 states, a massive win for gun owners and property rights advocates. If the court upholds the law, we could see an expansion of no guns by default zones nationwide, reshaping how the Second Amendment functions in daily life. Either way, this decision will define what bearing arms truly means in America for years to come. For many in the Second Amendment community, this case has been a long time coming. The idea that the Constitution could become an opt-in document strikes at the heart of what individual freedom is supposed to mean. As someone who closely follows these developments, I can say this one feels different. The facts are clear, the precedent from Bruin is strong, and the question is direct. Can the government override your right by default? This case could finally draw a firm line and stop states from sidestepping the Second Amendment through creative wording and loopholes. We'll be tracking Wolford versus Lopez closely right here on Guns Law Guide, from oral arguments to final decision. This is one of the biggest Second Amendment tests since Bruin, and its outcome could either strengthen or seriously weaken the right to carry across America. The court has a chance to make it clear once and for all. The Constitution is not something you opt into. It's the law of the land.